Hello, viewers and students. This is Dr. K.S.Neharkar, and I welcome you in my YouTube channel lecture series on labor laws. First, friends, today we are going to discuss the concepts of strike and lockout under Industrial Dispute Act 1947. So, friends, before this also we have discussed what is the concept of strike and its kinds. So you can find the concerned lecture on my YouTube channel at lecture series on labor laws first. But for the convenience, we are going to discuss both the concept here again. So friends, firstly, we must know what is the concept of strike and lockout. So as all we know, the strike and lockout are the two weapons available in the hands of workers and employer respectively, and these weapons are used by both, as strike is used by weapon by workers to pressurize the employer. Similarly, employer use the weapon of lockout to pressurize the employees. So these two weapons strengthens the bargaining power of parties. So in both concept there is no work. Friends, now we are going to discuss what are these two concepts. Firstly, we are going to discuss what is the concept of strike. Say friends, for that purpose we must go through the definition of strike that is provided by section 2q of Industrial Dispute Act. And according to this definition, strike means cessation of work by a body of persons employed in any industry acting in a combination or in concerted refusal under common understanding to accept employment or to continue to work. So, in a simple language, strike is nothing but the stoppage of workers who are employed in industry to work, and this is their collective act. So, this is the strike. The definition of strike provides that it is a stoppage of work, and all the workers are agreed to stop the work for particular purposes. So if we go through the essentials, uh, or if we go through the definitions, we can find certain essentials of strike. Here the first essential of strike is there must be the cessation of work. The term cessation of work is nothing but the stoppage of work. Work is stopped by the workman. So this is first essential. They refuse to work. They refuse to continue the work because they are disagree with the policies. They are disagree with what the decision which is taken by the employer. Therefore, to protest against such decision, to protest against such policies, the work is withdrawn by the workman. So the strike is nothing but a cessation of work. Strike is nothing but the stoppage of work. The second essential is it is a stoppage of work by a body of persons employed in industry. So this second essential provides that a strike cannot be declared in industry by outsiders, but it is a strike that is declared by the persons who are employed in industry or whose names are born on muster roll of industry. It means those persons who are going on a strike, these persons and the employer, there should be the employer employee relation. Then third essential of strike is there must be concerted refusal to accept the employment or to continue to work. So as we know, the strike is nothing but the cessation of work. But see, this is not the cessation of work by individual. This is not the stoppage of work by a particular single workman, but this work is stopped by all the workers in collectively. Therefore, it is called as a concerted refusal to continue to work. So, this is concerted or it is a collective act. Therefore, another next essential is also connected with earlier essential. So it is act in a combination. The strike or the stoppage of work, it is act in a combination. It means all the persons are agree to stop the work. They know what is the nature of their act. They know what are the consequences of that act. So by the common agreement, they decided to stop the work. So it is an act in a combination. And last essential of strike is the mental element in the strike is to continue the work after strike. So they have not permanently withdrawn the work, they have not permanently stopped the working, but they are ready to work, but they are ready to rejoin the work after the completion or the conclusion of strike. So these are some essentials. We have discussed what is the definition of strike and the essentials of strike. Now we must see what is the second concept, and that is lockout. Friends, as I already told you that lockout is nothing but a weapon in the hand of employer. Therefore, firstly we must see what is the definition of a lockout. Friends, according to section 2 clause L of Industrial Dispute Act, lockout means the temporary closing of place of employment. This is sufficient to understand what is the lockout. See, lockout is nothing but the temporary closing of place of employment. It means the employer has temporarily closed the workplace. It means he's not allowing workmen to attend the work, and this is done to pressurize the workman. So again come to the definition. So lockout is nothing but the temporary closing of place of employment, or it is a suspension of work, or the employer refuse the employees to continue to employ. So this is what the definition of lockout. And as we know, lockout is nothing but the weapon in the hands of employer. See, when the workers, they are not ready to accept what the rules, what the terms and conditions of employer, in such circumstances the employer can pressurize the workers by stopping the work for temporary periods. So it is the temporary closing of place of employment. So the employer shut down his place of business as a result of reprisal, a revenge, etc., and to use it as a coercive measure. So the object of lockout is pressurize the workers and to dictate his terms and conditions of employment. So if you go through the again definition of lockout, we can find certain essentials, and these essentials are as first thing is it is a temporary closing of place of employment. Similarly like in a lockout, here also the closing of place is not the permanent, but it is temporary, and the employer is going to reopen that place when his objectives are achieved by that act. The second essential is it is withhold of work by the employer. So the employer prevents worker from joining the work. So this is the second thing. So when he is not allowing workman to work, so this is the stoppage of work by the employer, we can say. But this is the withholding of work by the employer. He's not allotting work to his workman. Then next essentially is it is refusal to continue or to employ any number of persons employed in industry. So for the lockdown, it is necessary that all or whole industry should be locked. So it is not necessary. Even a part of industry may be locked, or even a few number of workers may not be allowed to work. So all those workers who are not accepting the demands of the employer, they may be stopped from working. So this is refusal to continue or to employ some number of workers. Then it is next essential is it is refusal or not allowing the certain number of workers to attend the work. And last essential we must understand is what is the intention of the employer behind the lockout. And it is intention of employer to reopen the place of employment after that lockout period. So friends, these are very two important concepts under Industrial Dispute Act that you must know, because after that we are going to discuss some provisions relating to legality or illegality of strike and lockout. And at that time you should know what are the concept of strike and lockout, because these concepts are going to be used for time and again. So friends, if you like this video, please like it, share it with your friends, and do not forget to subscribe my channel. So friends, thank you.